Strict liability and products liability are worth about 5 questions on the multi-state bar exam. So that means they're worth about 2.5% of that part of the test. Still, these concepts are quite important and they are frequently tested on the essays. So we'll consider strict liability first, and then we'll consider products liability. It's worth keeping in mind right from the beginning that strict liability is just an element of products liability, and it's also a separate theory of liability on its own. When we consider strict liability, apart from products liability issues, we're talking about abnormally dangerous activities and wild animals. And although we are considering strict liability fairly down on our list of torts, we've already considered intentional torts and we've already considered negligence. But strict liability actually is a stronger theory of liability for the plaintiff than either intentional torts or negligence. And the reason for that is, to be successful, a plaintiff need not show that the defendant is at fault. All the plaintiff has to do is show that the defendant did what the plaintiff alleged, and that's enough to establish a strict liability claim. So it isn't very difficult to determine that something may or may not be an ultra-hazardous activity. Suppose we've got an electrical power station. They are very common, and often little substations are spread throughout residential communities. Well, would we consider that to be abnormally dangerous? I think that on an essay, it would probably depend on the general circumstances. But by and large, high voltage probably is ultra-hazardous. Certainly a nuclear power station would be considered ultra-hazardous. And the classic common law fact pattern is blasting or other mining activities. Those are all ways that a plaintiff may find a defendant strictly liable and thereby recover compensatory damages. Strict liability is another area in which, absent a separate finding of recklessness or some intentional misconduct, a plaintiff is going to be limited only to compensatory damages. So, as we consider strict liability for animals, I think we can all agree up front that wild animals equals strict liability. So if we've got a defendant who's got a tiger at home, almost certainly any harm caused by that tiger is harm that the owner is going to be strictly liable for. With domestic pets, and with pets that can be considered either wild animals or domesticated pets, some little wild pigs come to mind, we'll probably have to examine it on a case-by-case basis. But if a certain type of animal is a common pet in a neighborhood, it's far less likely that the owner will be strictly liable. But remember the famous one-bite rule. After your lovable little dog has chomped somebody once, then it's foreseeable they will bite again, and subsequent bites may well incur strict liability for the owner. With regard to defenses to strict liability, there are relatively few, but the more outrageous the conduct by the plaintiff, the less foreseeable the harm will be. And although foreseeability is not really an aspect of strict liability, it is a concept that is floating around in the background. So if we've got a plaintiff who truly engages in ridiculously reckless conduct himself or herself, it is less likely that the defendant will be strictly liable. One example that comes to mind is a wild animal at a zoo. Now, if that wild animal escapes from the zoo and chomps somebody, that bite is going to incur strict liability for the zookeeper. But if we've got some other set of facts, like, for example, the plaintiff goes wading in a crocodile pond after climbing over a chain-link fence, well, at some point, the conduct of the plaintiff is going to be so unreasonable that strict liability seems like an unjust result. Now, products liability is by far the more tricky issue, and the reason for that is products liability itself isn't a theory of liability, even though it has the word liability in it. Products liability is better thought of as an umbrella under which 3 different theories of liability sit: strict products liability, negligence, and warranty. And the most common mistake that candidates on the bar exam make in the written section is to write only about strict products liability and to leave out the other two. Oftentimes, a fact pattern dealing with products will feature a designer, a manufacturer, and a retailer, and they'll all be separate defendants. And our job is to distinguish one from another. And so, realizing that products liability has more than one theory of liability built into it makes it possible to write a far better organized and a far more detailed answer. We'll take a look at a couple of products liability problems when we get to the hypotheticals, and we'll see that it's very difficult for the examiners to test products liability in a very complicated and clever way. Once you understand that products liability equals three different theories, strict products liability, negligence, and warranty, and that the same facts alleged can often establish all three of these theories, well, you are a leg up on your competitors when you know how to do that more sharply. Now, on the multi-state bar exam, the most common trick that they play is to confuse strict liability and negligence. And so, remember that no matter how careful the defendant is, if the plaintiff is injured by blasting by a wild animal, it is very likely that the reasonable care of the defense has nothing to do with a defense to strict liability. Now, the only hypothetical that I have briefly touched on where the reasonableness of the defendant really is in play would be a zookeeper where the plaintiff actually invades the compound and goes and tries to pet the lions or something like that. Under those circumstances, the zoo will establish that it did everything that it is legally and morally obligated to do. The defendant is not going to be strictly liable for a plaintiff that essentially commits suicide. And that is about how extreme it has to be for strict liability not to be a viable theory. The reasonable care of the defendant is almost never a valid defense to strict liability. I would say never, but you should never say never in the law, and this hypothetical of somebody jumping into a lion cage probably is enough to show that the defendant should not be strictly liable. Although, if the defendant did anything wrong, like, for example, make a cage accessible to the plaintiff, that might be enough for strict liability to attach. Now, as we consider products liability, we realize, most importantly, that there is an umbrella under which sit strict products liability, warranty, and negligence. Most of the liability theories are based on negligence, although we will see that acts of negligence equal strict liability. So, as we consider design defects in an item that ends up causing injury, the design defect would be an act of negligence. Failing to design a product safely is, by its nature, careless, and that carelessness can result in a finding of strict liability if somebody is injured by that product. And obviously a defective design can add up to negligence as well. So we consider defects in design, and then we consider defects in manufacturer. These also typically are acts of negligence that also add up to strict liability. And so on an essay, we will often have to determine what's wrong with the product. And sometimes the product will be both defectively designed and defectively manufactured. But sometimes the defect will only occur in one area, not the other. The result will be various defendants will either be strictly liable or have a good defense to strict liability. If all of the misconduct was done at the design phase, the manufacturer has a credible defense. Notice I say a credible defense, not necessarily a successful defense. You have to do a lot of practice, read the questions carefully, and you can see what a lot of hair splitting you'll be doing, particularly on the multi-state bar examination. So, to establish a claim for strict products liability, the plaintiff has to show that there is a strict duty owed. Typically, that is not very difficult to do for either a manufacturer or a retailer. Also, the plaintiff has to show a breach, causation, and damages. Structurally, this is very similar to negligence. But notice the difference is, as opposed to a general duty of reasonable care, or maybe the higher order of care that is required of innkeepers and common carriers, here the plaintiff has to show a strict duty. And whenever we have a manufacturer or a retailer placing products into the stream of commerce, that duty is typically going to be present. With regard to breach, causation, etc., here we have to analyze the facts specifically, either on an essay or on a multi-state question, in order to resolve that problem. So, defects in manufacture and defects in design both can add up to strict products liability. But realize they also can constitute acts of negligence, and negligence in products liability is analyzed in exactly the same way that it is generally. We consider duty, breach, causation, damages, and defenses. Now, we consider negligence under products liability, and we see, obviously, that it's a much weaker theory of liability than strict liability. Because with regard to negligence, we have to show misconduct by the defendant, and we also have to the plaintiff is also subject to the defenses of contributory and comparative fault. And one thing that you'll see on multi-state and essay questions about strict liability, particularly products liability, we will see plaintiffs with very low IQs. We'll see plaintiffs do a lot of stupid things. But those stupid things, although they may absolve a defendant from liability for negligence, they almost certainly will not absolve that defendant of strict liability. Finally, with regard to warranty, we consider that there is a warranty of merchantability and a warranty of fitness for a particular use. These are not identical, and we'll see questions, especially on the multi-state, that can split hairs between these two different warranties. With regard to defenses to products liability, we see that assumption of risk can be a defense to strict liability, but comparative fault typically is not. Finally, we will see over and over again that the examiners are testing the same basic ideas, both in strict liability and in products liability. You don't need to do a lot more upfront studying than I have given you just in 10 or 15 minutes of talk on this topic. Go in and do a lot of practice, and you'll see that the examiners are testing these issues in an almost ritualistic fashion. You need to be experienced with how the material is tested. The law itself, both in strict liability and in products liability, is quite straightforward. So that concludes our consideration of those topics. Next, we will consider what the National Conference of Bar Examiners helpfully refers to as other torts.